This conference will now be recorded.
Welcome. It's Friday, October 30th, 2020. Happy Friday. I'm Stephanie Schneider, board certified elder law attorney, and welcome to today's webinar where I'm going to be speaking about the 5 most important things parents of children turning 18 as well as minor children need to know. So I'm going to share my screen and we will proceed with the PowerPoint presentation. So we spend a lot of our time, a lot of our life raising our children. We teach them important values. We teach them manners. We help them with their homework. We strive to have them achieve good grades so that they can attend college. And there are a lot of things we can do, but there are also things that we don't realize we can't do once they reach age 18. Now, before they become an adult at age 18, we as the parents are considered to be their natural guardians. This is a legal term of art, which means that we can make their medical decisions, we can make their financial decisions, we can give authorization for medical treatment, take them to the pediatrician, we can select what school they're going to attend. We naturally are able to do these things. In addition, if our child were injured and we filed a lawsuit and the amount of money that's going to go to the child is less than $15,000, when we can settle the lawsuit. And this applies regardless of whether the child who has been injured is healthy or has special needs or was born with a developmental disability. But again, what's important to understand is we can only do this until the child is age 18. That is an important dividing line in their lives and in our life. So what happens when they're turning 18? Well, for most people, we get busy planning the graduation party. Where's it going to be? Who's going to be invited? What is going to be part of the celebration? Or our minds might be on planning the last family vacation when everybody can be together and have a great time before our 18-year-old son or daughter goes off to college. Or we might be very busy getting them ready for that next step in their life. We might be picking out the things that they're going to need for their dormitory room, meeting with the new roommate and their family. All these things naturally come about either toward the end of December or May, depending on when our child is going to graduate. If our child has decided to enlist in the military, then we're doing things to get them ready for that transition in their life. But my goal today is to let you know all these things are wonderful, they're a lot of fun, but let's not forget that they need a legal plan. So, what exactly does it mean when they turn 18 years of age? Well, in the eyes of the law, it means that they are now a legal adult. We may still refer to them as our child, our baby. We are probably continuing to pay for things like car insurance and other things that are important for them that they cannot financially yet afford to be responsible for, but as an adult, they can vote in our local elections as well as the national election. They can enlist in the military. They can even get married without our pre-approval. They can make their own medical decisions. And I know this is hard for many people to hear. And what this means is if something happens when they're away at college and they go to the infirmary, because of a law called HIPAA, and we're going to talk about this in just a few minutes, it does not mean that the school or the infirmary is necessarily going to contact you. And our children can make their own financial decisions. So if they happen to have a bank account in their name, your name is not on it as a joint owner, then they have the privacy as an adult of being able to handle this account, and you are not entitled to get any information from the bank. So you might be hearing some of these things for the first time, and it might come a little bit as a surprise or a shock, but by you attending today's webinar, you're going to learn a lot of really important information about how to plan ahead so you are prepared for when there are unanticipated, unforeseen events that happen. So what are some of the unanticipated events that can happen in anybody's life that might lead to our young adult child becoming incapacitated? And what exactly does incapacitated mean to us? Well, incapacity in the eyes of the law means that an adult is unable to make informed medical choices, or could be unable to handle their financial affairs because something is impacting their judgment, their reasoning skills. It could be that there's a physical illness. It could be that there's an injury that's affecting them. So how would our young adult child become incapacitated? Well, statistics tell us that between the ages of 18 and 25, that age group has the highest statistic for being involved in an automobile accident. You know, driving is new to them. There can be many distractions these days, especially with technology, phones, texting, things like that. So unfortunately, I do see in my law practice parents that call my office because they have a young adult child that was in an accident and they are not completely competent and able to make their own healthcare decisions. Or there could be an illness, a diagnosis that was unanticipated, unexpected, that could impact the young adult's ability to make medical decisions, to give informed consent, or to possibly handle their financial affairs. One of the things we do see, unfortunately, when our 18-year-olds go to college is they're given a lot of freedom that perhaps they didn't have before, and there is the influence of peers. And so we sometimes see young adults going into hospitals due to alcohol poisoning. So this is, again, another unanticipated type of event that could cause a young adult child to become either temporarily or permanently incapacitated. And then unfortunately, our society in the United States is witnessing more shootings, both on college campuses as well as in grade schools. And injuries are occurring that can affect a young adult's capacity. So we want to be prepared because the last thing we want to hear is that we're being told information cannot be released to us as the mother or the father because of HIPAA. So what is HIPAA? HIPAA is the medical privacy law that became federal law in the year 2004. Now, when the bill became law, it had a very good intention. And the intention was to enable different medical providers, whether they're hospitals, a laboratory, a facility, to be able to easily share information, especially electronically, to benefit the patient, so that all medical providers that were involved with a particular individual, although they may not know about other providers, could easily share information. It would be accessible. Another good intention of the law was to protect medical information that is considered to be confidential so it didn't get into the wrong hands, so that information was protected and was not handled in a careless manner in the healthcare system. So those were good intentions. However, what many people were unprepared for when it became law is that there needs to be written authorization for confidential medical information to be released to another person other than the patient. So probably in the last 16 years, you may have gone to a doctor's office, and upon checking in, you were greeted by the receptionist and you were given a piece of paper called a HIPAA release or a HIPAA authorization. And most likely at the top of the page or somewhere on the paper, it referred to the particular doctor you were seeing that day. So that authorization is only good for that doctor, as opposed to being good and universal for any doctor, any healthcare provider you might see. So HIPAA can prevent us as parents from getting important information we would need to make medical decisions for our adult child if the child became incapacitated. So it's important that we understand what HIPAA is and how do we get access to that information if our child is temporarily incapacitated due to an unanticipated event. So young adults need to have a legal plan, just like you and I, as parents, need to have a legal plan for us. So today we're going to talk about the two important aspects of what make up that legal plan. There's the financial decision-making side, and there's the medical decision-making side. So first, we're going to talk about and explore how can we make financial decisions for an 18-year-old or older young adult. The first document that's very important is the durable power of attorney. So as the first word says, durable means it gets us through that time when somebody is incapacitated. If you remember back to some of the really great and even funny, because we laughed at them, commercials that the Ever Ready battery put out over the years, where the bunny who had the batteries in them would go through fire, would go through water, and kept going because the batteries were durable. Well, that's the point about this legal document. It works when we're ill, we're incapacitated, we're disabled. And it is key because as an adult, we each are given legal rights. And at 18, our parents can't exercise those rights for us. So let's say that your child was at college and had an accident and needed to leave school for some period of time. And one day you or your child get in the mail a letter from whoever the student loans were taken through. And because your son or daughter stopped school, they may be looking to have loans repaid. Or there's another financial issue that comes up. How are you going to handle it? Well, without the durable power of attorney, the only way you're going to be able to handle it is to go to an elder law attorney and seek a guardianship, which is a court-supervised proceeding that would appoint you as your adult child's guardian to make medical and financial decisions. Unfortunately, it takes time. There is a process for a guardianship absent an emergency situation. It is also a proceeding that can be expensive because it can stay in place for years until the child possibly recovers and can have their legal rights restored. And to some extent, there is a loss of privacy because today many court records are a public record and can be seen right on the computer. Whereas the durable power of attorney is a private document. It doesn't get recorded, it's not filed with the court, and it will enable you to speak with financial institutions and financial providers and to sign anything that might be necessary on your child's behalf. So I highly recommend that before they leave for college, they sign a durable power of attorney. Now, I mentioned there's a second aspect to the legal plan. We refer to that as medical advance directives, meaning these are written legal documents that give direction, give instruction should the adult child become temporarily or permanently incapacitated. So we're going to talk about each of the different types of medical advance directives and what role they play in our child's life. The first and probably the most important medical advance directive is called the designation of healthcare surrogate. So a surrogate is somebody that your child names to stand in their shoes and be their advocate, be their spokesperson, be able to talk with the doctors, the hospital, the rehab facility, and to understand what the diagnosis is, the test results, and what is the proposed course of treatment options that are available. So the surrogate would make those decisions that the adult child is unable to make. It could mean that if you do not like the care that your child is getting at a particular hospital or facility, you can call in a second opinion. You can request release of medical records to be seen by another provider. You could authorize the discharge of your child from the hospital and select a different hospital or facility that you think would provide a better level of care or has more expertise in the area that your child needs. The next important medical advance directive to have is called a HIPAA authorization for release of confidential medical information. So remember a few minutes ago we talked about the HIPAA law and that could prevent you as the parent from accessing important information you need to make the best decision for your child. So the HIPAA authorization that I create does not have the name of any healthcare provider in it. It's intended to be universal and to be used no matter where your child goes, no matter where they are living. So what's important about this is that your child is giving permission in advance. It will designate you, your spouse, or whoever they have named as the trusted individual to be able to access the confidential medical information needed to make their medical decisions while they're incapacitated. So those two documents to me are the foundation. This is what they need before they leave home. Now the other three documents that we're going to talk about are dependent upon whether your child and you are ready to discuss them. Some of these are issues that you might not have previously discussed with your child. You may feel that they're too young or that they're just not ready to address these issues, but I want you to be aware of them. The first one is called a living will, and this is a document that enables any adult over age 18 to indicate their preferences for end-of-life care should they be diagnosed with a terminal illness, one that is going to reduce the natural life expectancy. Although we tend to think of addressing these issues when we're much older, I'm actually going to share with you a couple of stories that show us why it's important to actually address this at a much younger age. For those of you who may not have been living in Florida a long time, about 15 years ago, we had a situation over in Tampa, Florida with a young woman named Terry Shivo. And Terry had an eating disorder which went unattended for a while and ended up causing cardiac issues for her. So she was found unresponsive one day and 911 was called. The ambulance took her to the hospital and she did not have any of the advance directives that we're talking about in today's webinar. So as a result, the doctor at the hospital who was issuing the orders put her on life support equipment. She was on life support for many years. Her husband applied and became her guardian. And unfortunately, a legal battle ensued between her husband as guardian and her parents as to whether or not life support should be removed after a certain period of time had passed and there was absolutely no improvement, no change in her medical condition. Now, had she had any of these medical advance directives in place, but probably especially the living will, I tend to think that the legal battle would not have gone the way it did, where it tore apart her family and went all the way up to the Florida Supreme Court. Another situation that I witnessed in recent years here in Broward County was a situation in which a young adult male was killed, and his parents were divorced prior to his passing, and the parents could not agree on whether their son was to be buried or was to be cremated. And again, unfortunately, he had no medical advance directives. The subject had not been discussed, and it became a legal matter in our probate court. You know, we don't like to see families torn apart. It's very hard enough when a child becomes sick, ill, or passes unexpectedly. So I do suggest that we take this time to educate ourselves first so that we can explain it to our child in a way that they can understand. And while they may not feel they're ready, at least we've broached the conversation and we can revisit it at another time. So one of the other medical advance directives to talk about with our young adult children is a declaration of organ donation. Now, we can on our driver's license indicate whether we would like to be an organ donor, but by having this additional document, we can make more specific decisions. For example, we can indicate whether we would only want certain organs or body parts to be donated, and we can also specify, do we want those organs or body parts to be used for transplantation if they're healthy enough? And if not, would we want them to be used for medical research and study? So that's a very important advance directive to consider. Another advance directive is what we refer to as a declaration of funeral designee. Now, this document serves two purposes, and you'll understand the last story that I explained to you and why I recommend this. The first goal that the document achieves is it designates the person that you or I would want to make final arrangements. That person would then have the authority to speak with the funeral home, with the medical examiner's office. The document serves a second purpose in that it indicates whether the individual wants their physical body to be cremated or buried, and any special requirements regarding, do they want a service? Where would they want the service? Do they want a celebration of life or not? Or are there certain religious observances that they would want their funeral designee to know about and to be able to honor? So these are 5 medical advance directives, 2 of which we definitely need to have. We need the surrogate who's going to make our medical choices, and we need the HIPAA authorization. In addition to that, we have the other 3 for you to consider. So when is the timing important? When should our 18-year-old have this plan put in place? Well, in the ideal world, I'd love to tell you, come see me in the early spring if they're graduating in May, or come see me in the fall before they're going to graduate in November or December. But that doesn't always happen. So we have other options. Keep in mind that if your child is going to come home to join the family for the Thanksgiving holiday or over winter break, those are also 2 great opportunities to have the dialogue with your child and to set up a consultation with me so we can get these documents in place before they either go back to school or they go to live on their own and start their first job. So what about our minor age children, children that are under 18? Because some of us have adult children and some of us have minor age children. What should we be thinking about for them? What can we do for them? Well, a few years ago, Florida passed a new law, which we needed for a very long time, so I was very happy when it became law. And it allows us as a parent to sign a document called a designation of healthcare surrogate for a minor. What does that mean? Well, it means that if we happen to be away from home, maybe we're traveling on business, or we might be on vacation. Hopefully, we'll be able to return to traveling once we move past and we resolve the COVID-19 virus. It allows the person that we are entrusting to take care of our child, it allows that person temporary medical decision-making authority. So they can speak with the pediatrician. If our child needed to be taken to a hospital for treatment, that person can give informed medical consent in our absence. To me, this is a great tool, one that we all should have for our children that are under age 18. The second legal tool we want to be thinking about is called a declaration of preneed guardian for a minor. And it means that if, God forbid, we as the parent should become incapacitated and unable to make medical or financial decisions for our child, or God forbid, we passed away unexpectedly, this document says who we want the court to appoint as a guardian of our minor age child. Now, the document creates a presumption. The presumption is that the court will appoint the person you name in the document unless when the court does a background investigation of the person, they find that this individual has been convicted of a felony. In Florida, any person who's convicted of a felony cannot serve as a legal guardian. So who would you want to think about selecting as guardian for your child? Because you need to think about a guardian for medical decision making and a guardian for financial decision making. And it does not necessarily need to be the same person. For many people, they will select one person for medical decision making. That person would also be the individual making the decision about where the child would live, what school they would attend. And so you want to think about matching the guardian with the responsibilities. Who in your life do you feel, perhaps as a parent themselves, they have similar values, ethics, morals? You feel that they can handle the responsibility, they handle pressure well, versus who do you feel has the life experience or the skills to handle any monies that your child might receive if you're incapacitated or you've passed away and perhaps left the child in inheritance. So you can name different individuals for the two different roles. Once the document is signed, we electronically file it with the court. And should you become incapacitated and a guardianship is filed for you, or should you pass away and documentation to that effect is filed with the court, then the court will be able to cross-reference it with this legal document, and it will be produced for the judge when the necessary papers are filed seeking a guardianship for your young child. So these are two important documents that I feel every parent needs to have for a minor age child. Now, let's not forget families who have a child with a developmental disability, because they need planning too. It's just a little bit different how we go about putting the plan together. So we need to first determine and look at what is the capacity, the level of awareness, the level of understanding of this 18-year-old who either has special needs or a developmental disability. And the way in which we determine that is to actually meet with the child and have a conversation, as well as speaking with the parents to understand what level of education the child has completed, what kinds of decisions can they make safely, what can they not do, are there safety issues. So from there, we would determine whether the child has enough capacity, understanding, to be able to create medical advance directives or to create a durable power of attorney. Now, in the law, there are different levels of awareness that are needed. So a higher level of awareness is needed in order to prepare a durable power of attorney for an 18-year-old that might have special needs or developmental disability. So we're looking for an understanding and awareness by them of what are their assets, where are they located, who are the immediate members of the family, do they know where they are, the date, the time, the place. That is a higher level of capacity that is required, whereas a lower level of capacity is required to do medical advance directives. So sometimes a person may have the necessary capacity to do both documents, or they may only have the level of capacity to do the medical advance directives, and then we're going to explore what tools are available to allow the parents to make the financial decisions for the child when they are age 18. So in Florida, we're very lucky to have two different court proceedings that are both options for our 18-year-olds that have special needs or a developmental disability. One proceeding is called guardianship, and the other is called guardian advocate. And we're going to walk through what are some of the differences and when might one proceeding be more appropriate for your child versus the other. So one of the first differences is that in a guardianship proceeding, the court is actually making a determination as to what legal rights the adult child should keep and what legal rights should be taken away. So let's just run through quickly what are the legal rights that every adult, once they become 18, has. Well, we all have the right to get married. We have the right to vote. We have the right to apply for government benefits. That might be to the Medicaid agency, the Social Security Administration. We have a right to apply for a driver's license. We have a right to sue somebody that might have injured ourselves or defend a lawsuit if we caused an accident. We have a right to sign contracts. That could mean a contract to purchase a car. We have the right to travel, decide where we want to go, who we want to associate with and socialize, where we want to live. We have the right to apply for a job, to manage our own property, and to make our own medical decisions. So in a guardianship, the judge is making a determination based upon evidence and testimony, and a medical examining committee that goes out to meet with the individual. The judge is ultimately deciding what rights are kept because they can be safely exercised and what rights are going to be removed. Whereas in the guardian advocate proceeding, the judge is not removing any legal rights. All those rights stay intact for your young adult child. Now, it's been my experience working with families over the years that have a child with special needs or developmental disability is they would prefer not to remove their child's rights and give the child continued opportunity to learn, to grow, to mature with the guidance of the parents and the rest of the family. So legal rights are kept intact with the guardian advocate proceeding. Whether you become a guardian or you become a guardian advocate, you will have the legal authority to be able to do the things that the court authorizes in the order that is going to be signed. So in a guardian advocate proceeding, for example, if your child were to go to a dentist for an annual checkup and x-rays are taken or other dental exams are performed and the doctor finds something and explains it to your child, but your child cannot understand the different approaches to treatment, can't give informed consent, that's where you, as the court-approved guardian advocate, would be able to give written informed consent. So you are there supplementing and helping your child to understand the decision that has to be made. Whereas in a guardianship, you are making the decision directly. The child is not involved. Now, guardianship and guardian advocate generally tend to last throughout a person's lifetime unless or until that young adult is capable of having their rights restored. And sometimes we do see this. For example, when a young adult is involved in a serious car accident, it may take some time. It could take years just for the body to heal and for the child to go through various therapies and rehab. But sometimes it is possible to have the court restore legal rights. So that is a possibility in a guardianship. It generally is not something we see happen in a guardian advocate proceeding. A couple of other tips and information I'd like to share for the parents that are watching this webinar who have a child with special needs or disability is things you want to think about as they're in their 17th year, they're approaching their 18th birthday, and that is certain government benefits that might be available to them when they become a legal adult. So the first program to be aware of is through the Social Security Administration, and it is called the SSI program. SSI stands for Supplemental Security Income. Now, to qualify, there are 3 basic eligibility requirements. The first one is that the person applying must either be a certain age, found to have been determined to be blind, or is disabled. So if your child is blind or disabled, they will meet that requirement, and that is based upon medical documentation you'll need to obtain from the doctor's office. The second requirement is resources. So resources are things that are financial. They are our bank accounts, our investments. Your child needs to have no more than $2,000 of resources in their own name. Now, here's what's important to understand. If you were to apply for SSI for your child before their 18th birthday, they are still a minor, and under the law, the Social Security Administration is allowed to look at the parents' resources and income, because there is a presumption that some portion of the parents' resources and income is being used for the support of the minor child. But once your child becomes an adult, they stand on their own, which means that no government agency is permitted to look at the parents' resources and income. So for many people, it's much easier to qualify the child once they turn 18. So wait until a day after their 18th birthday before you apply. And you can apply online at the Social Security website, which is www.ssa.gov. The third requirement to qualify is the child must have limited gross monthly income. Now, the figure I'm giving you is only good for this calendar year, so that's through the end of December, because come January 1st, it is likely there will be a cost of living adjustment and that number will go up. So right now, if you're going to apply for SSI before December 31st, your child must have less than $783 of gross income per month. So income is going to include any employment, wages, anything that they are earning. Now, if they meet those 3 eligibility requirements, what are they going to get? Well, first they're going to receive from Social Security a monthly cash benefit. Now, they can receive this in one of 2 forms. Either an account will be set up for them and the money will be electronically deposited, or Social Security may offer the option of giving them an electronic card, and each month Social Security will download the amount onto the card for them to use, almost like a debit card. Now, if you think that your child doesn't have the wherewithal or the maturity to handle the money, then at the time of applying, you're also going to apply to become what is called their representative payee. So this means that you will be responsible for receiving and applying the SSI monies on their behalf. In Florida, and this is not in every state, it's in some states, when you receive at least $1 of SSI benefits, you automatically get approved for basic Florida Medicaid assistance without having to go file an application with the Department of Children and Families. So that's an added bonus for Florida residents. Now, another benefit I want you to be aware of so you can be prepared is referred to as childhood disability benefits. It has an acronym DAC. This is a benefit that your adult child can apply for when and if you become disabled as the parent, or you retire from employment, or you pass away. So here's what the child is going to need to show. Number one, that the child was disabled before age 22. The child is unable to be substantially gainfully employed, and that the child is unmarried, or if the child is married, that they are married to another person that is also a recipient of this benefit. There is basically no resource limit, no income limit, and here's the bonus. They are getting the benefit based upon your tax record with Social Security. So it is likely that they are going to get a higher benefit through DAC than they got through the SSI program. Now, what if they get a higher amount? Well, then the likelihood is they'll no longer get the SSI. And don't worry, they're not going to lose the Florida Medicaid basic benefits, because under federal law, their Medicaid is protected even though they're getting a higher amount of monthly income through this program. So that's good news. The other program to be aware of in Florida is our Medicaid Developmental Disability Waiver Program. Now, this is handled through the Agency for Persons with Disability. Don't go to DCF, they don't handle it, it's APD. And this is to help people who are born with a developmental disability as opposed to people born healthy, but then there was an accident or an illness. So anybody who's age 3 and older is eligible. However, you do need to know that we have not had sufficient funding for this program. So there is a waiting list, but I do encourage my clients to put their child's name on the waiting list when the child becomes a legal adult. There is a resource limit, which currently is $2,000, and there is a monthly gross income limit, and that income limit will tend to change each year. But if your child is able to come off the waiting list and is approved for services, they will be given a certain budget, which their support coordinator will help you and them decide how to allocate to things such as supported living services, therapies, and employment training, employment services. So keep this information. Look at it when your child is approaching their 17th year, before their 18th birthday. So in concluding, I'd like to give you a couple of tips to help you get ready, get organized to take the next step. So I suggest your first step would be talk with family members, talk with friends, to think about and start to make some decisions on who you're going to select to be your medical decision maker, your financial decision maker, who you would want to name as an alternate, a backup person. And the same tips I'm giving you would apply to your young adult child thinking about their legal plan and who they're going to name as their decision makers. For you, because you're most likely going to need a last will and testament or a trust, you're adults, you've been working a while, you've accumulated wealth, you want to start to also think about who your beneficiaries are going to be. Who do you want to inherit when you pass away? And does that beneficiary possibly need a trust for their inheritance because they may not be mature enough, maybe they're not fiscally responsible, maybe they have special needs, so they need a special needs trust. You might have a beneficiary, unfortunately, who has an addiction, so there's a certain kind of trust that we would write for that beneficiary. You want to think about who do you trust to serve as the trustee to manage that trust. It could be an individual or it could be a corporate trustee. Start to also think about who you trust to be a healthcare surrogate for your minor age child, as well as who would you want to name as a guardian to make medical decisions for your minor child and to make financial decisions for your minor child in the event you were to become temporarily incapacitated or pass away. And then most important, talk to your child as they're approaching their 18th birthday. It really is important for them to have a legal plan before they go off to college or to the military. And then most of all, meet with an experienced, qualified attorney. I know there are a lot of attorneys advertising out there, and sometimes it can be confusing. How is one attorney different than another? Ask for their qualifications. Are they board certified in a specific specialized area? You know, you wouldn't call up just a general doctor if you were having cardiac issues. You'd go to a cardiologist, you'd go to a specialist. So the same advice applies to law. We have different areas we specialize. I'd like to invite everybody who's joined me today for our next webinar series in November. You can go to my website, www.fl-elderlaw.com, to our calendar page where you can see the upcoming topics and register. If you've missed a webinar and you were interested in a topic, you can go to our resources page and see all the recorded webinars and register to watch them in the convenience of your home. And please share this information with friends and family. You can also go to the Contact Us page on the website, where we have both a free document checklist to help you start to organize your thoughts before scheduling a consult, and we offer a gift certificate for a 20% discount on the initial consultation. So I want to thank everybody who's joined me today and open it up for any questions. You're welcome to either unmute your microphone or you're welcome to type a question in the chat box. So I see there are no questions, so I'd like to wish everybody a healthy and a fun weekend. Enjoy Halloween, be safe, and thank you for joining me today.